We would like to start the leftover concept of Indian constitution or constitutional law, and that is contempt of court, which is one of the important aspects of constitutional law. So, in relation to that, we would like to the constitutional provision as regards to contempt of court, and that we found under Article 129, and that Article 129 provides that the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. And in the same manner, Article 215 of the Constitution provides the same provision regarding the high courts in India. As such, they are also having the same jurisdiction as courts of record, so they also enjoy all the powers, including the power to punish for contempt of itself. And as such, also we found under Article 142, Clause 2, which provides the Supreme Court's exclusive punishing power, and the very Clause 2 of Article 142 expresses that subject to provisions of any law made in this behalf by Parliament, the Supreme Court shall, as respects the whole of the territory of India, have all and every power to make any order for the purpose of securing the attendance of any person, the discovery or production of any documents, or the investigation or punishment of any contempt of itself. So, the very article, that is Article 142 itself, provides that which was decided and pronounced in certain important leading cases by our Supreme Court, and that was Anita Kushwala versus Pushpa Sudan in 2016. So in the leading case, Brij Mohan Lal versus Union of India in 2012. So another important leading case, D.K. Basu versus State of West Bengal in 2015. Our Supreme Court expressed that in connection to Article 142, an ordinary law or statute cannot control the exercise of power by the Supreme Court under Article 142 of the Constitution. And in relation to that, we had to discuss the very provisions of contempt of Court Act 1947, which we would like to discuss. The contempt of Court Act 1971. So, as regarding the very definition and meaning of civil contempt that we found under section 2 subsection B, which provides that any willful disobedience to a process of court and also willful breach of an undertaking given to a court would constitute a civil contempt. And as regarding criminal contempt, that as defined under section 2 subsection C, that which includes the criminal contempt, which includes any act or publication which scandalizes the court or prejudices any judicial proceeding in the court or interference with the administration of justice would constitute criminal contempt of the court. So also the very punishment and its interpretation that we will discuss as under section 20 of the Act, it would be simple imprisonment for a term which may extend to 6 months or with a fine which may extend to 2,000 rupees or both. And their interpretation, as we found by the very observation of a Supreme Court bench consisting Justice Khanna and Justice Dipankar, that who interpreted it as that contempt of court includes as under section 480 of the Indian Penal Code for offences committed under section 175, 178, 179, 180 and 228 of Indian Penal Code, also section 345 of the Criminal Procedure Code 1973, and as regarding the very time limit, it must be within a year of contempt is alleged to have been committed as it was interpreted by the Supreme Court bench of Justice Sanjeev Khanna and Justice Dipankar Dutt. So now in relation to that, we would like to discuss certain important leading cases relating to contempt of court, and in that regard first we would like to discuss the important leading case Bitusa over a case of 2017. So, in that case, Supreme Court observed that the court under Article 2, 129 and the High Courts under Article 215 of the Constitution are both declared to be courts of record. One of the recognized attributes of a court of record is the power to punish for its contempt, and the contempt of courts subordinate to it, as it was observed by the Supreme Court on its own motion in this particular important leading case with Oberoi in 2017. And in regards to contempt of court, we would like to discuss another important leading case, and that is Mohit Chaudhary's case in 2017. Also, the court of its own motion discussed that in relation to contempt, jurisdiction is not only to protect the reputation of the concerned judge so that he can administer justice fearlessly and fairly, but also to protect the fair name of the judiciary. The protection in a manner of speaking extends even to the registry in the performance of its task, and false and unfair allegations which seek to impede the working of the registry and thus the administration of justice made with oblique motives cannot be tolerated in such a situation. In order to uphold the honor and dignity of the institution, the court has to perform the painful duties which we are faced with in the present proceedings, as it was pronounced by the Supreme Court in the important leading case Mohit Chaudhary in 2017. And now we'll discuss another important leading case, that is Hetram Beniwal versus Raghuveer Singh, and it was decided by the Supreme Court in 2016, where it was observed that the power under the Contempt of Courts Act 1971 has to be exercised sparingly and not in a routine manner. If there is a calculated effort to undermine the judiciary, the courts will exercise their jurisdiction to punish the offender for committing contempt, as it was declared by the apex court in this important leading case, Hetram Beniwal versus Raghuveer Singh in 2016. Now we'll go to discuss another important leading case relating to contempt of court, and that is Leela David versus State of Maharashtra in 2010, where the very contempt of Supreme Court and regarding the very observation as it was observed, Supreme Court as a guardian of right to personal liberty cannot do anything by which that right is taken away or average, especially when Supreme Court is acting suo motu, as in proceedings for its own contempt. And now we'll go to another important leading case, that is State Bank of India versus Kingfisher Airlines Limited in 2017. The power of Supreme Court was discussed and pronounced as the Supreme Court can take action for contempt of itself as well as for contempt of subordinate courts, including the high courts, as it was pronounced by the Supreme Court in this important leading case. And now we'll discuss one of the most important leading case, that is Honorable Justice C.S. Karnan and the very ruling of Supreme Court in this particular important leading case, that the very fact of the case is relating to that Justice Sri C.S. Karnan was for his very actions on invited actions in courtroom, and also he accused many high court judges as corrupt, impartial, and dependent, even accused the then Chief Justice of Madras High Court. In 2017, it was observed by the Supreme Court in this case the very allegations labeled by the contemner were not supported by any material. His allegations were malicious and defamatory and pointedly by name against many of the concerned judges, even the Chief Justice of Madras High Court, during the course of hearing of the contempt petition. His ridicule of the Supreme Court remained unabated. The actions of contemner constituted the grossest and gravest actions of contempt of court. He was therefore held liable to be punished for his unsavory actions and behavior, and was awarded with imprisonment for 6 months in this important leading case, that is Honorable Justice C.S. Karnan in 2017. And now we'll discuss another important leading case, that is Vijay Kurle in 2020. The Supreme Court in this particular important leading case relating to contempt of court, the accused Vijay Kurle sent letters to Chief Justice of India, the then Chief Justice of India, Ranjan Gogoi, and labeling scandalous allegations against Justice R.F. Nariman and Justice Binit Saran and it was held as serious charges and allegations against the acting and presiding judges of the Supreme Court, such as Justice R.F. Nariman and Justice Vinit Saran. So he was punished for contempt of the court as provided under the Contempt of Court Act 1971, and now we'll discuss another most important leading case of 2020, and that is Prashant Bhushan's case in 2020, that it is a case relating to Prashant Bhushan and another, and here Prashant Bhushan tweeted two comments on administration of justice and especially on the then Chief Justice of India, Justice S.A. Bobde, as making such allegation that during the last 6 years the Supreme Court was destroying India's democracy. So, the Supreme Court took sumo cognizance of the tweets tweeted by Prashant Bhushan and another, and accordingly held such tweets as contempt of court and punished as per the provisions of the Contempt of Court Act 1971. And now we'll discuss another important leading case, and that is relating to Aditya Kashyap versus Rachita Taneja in 2020. And exactly the very fact of the case we would like to discuss. Rachita Taneja, the defendant, who was a cartoonist, tweeted objectionable content to degrade the authority of the Supreme Court in the eyes of the public, and accordingly it was held as contempt of court, and the very defendant was punished as per the provisions of Contempt of Court Act 1971. And the last important leading case relating to contempt of court is also a case of 2020, and the very important leading case is Abhyuday Mishra versus Kunal Kamra. And as very fact of the case is that Kunal Kamra made publication of tweets on social media scandalizing the court. Why? Degrading its authority. And as Kunal Kamra was a voice stand-up comedian, and as the very publication of tweets on social media scandalized the court, so it degrades the very authority of the Supreme Court by the stand-up comedian Kunal Kamra. So who was held and punished as under the provisions of punishment as provided under Contempt of Court Act 1971, and it was held as a criminal contempt by the court. So, in this video, we have discussed the most important aspects of Indian Constitution relating to contempt of court as specifically provided under Article 129 as Supreme Court as a court of record, and also Article 215 as regarding how high courts in India as courts of record. So also Article 142 Clause 2, the very provision relating to Supreme Court's exclusive punishing power. And also we have discussed and defined the very provision under Section 2, subsection B, relating to civil contempt, and Section 2, subsection C, relating to criminal contempt. And as also we discuss the most important leading cases relating to contempt of court as decided by the apex court. So, in our upcoming video, we will discuss the very original jurisdiction of the Supreme Court as provided under Article 131 of the Constitution.